Hi, Christine Faulkner with Kava and Faulkner Elk Rose, trust and estate planning attorney. And thank you for tuning in for another edition of Catching Up with Christine. Today, I thought I would talk about why you might need to have a trust, even if you don't have the kind of assets that would trigger a probate. So, in case you don't know, if you have titled assets that are worth more than $166,000 and you pass away, especially if you're single, so take for example, you own a home and you have that home titled in your name alone, and you pass away, and the fair market value of that property is worth more than $166,000, then that asset is going to end up in a court process called probate. And I'm not going to go into detail about that other than to say what that means is that you lose all control over who receives that asset because it is dictated by statute. So a judge will look at that statute and figure out who's part of your life. But here's a couple of things you need to know about probate. It is quite time consuming. So on average, a year to a year and a half in California to get through probate. It really depends on the number of assets that are being probated and how simple or complicated things are. It is also public, so people do attend probate hearings to find out who is coming into what money. So if you value your privacy, that might not be ideal. Your children, if you have children or beneficiaries, will get everything outright once that probate order is issued. And so if you have young beneficiaries or young children, once they turn 18, they get everything outright. There's no way for you to control that. And the cost. The cost is quite significant. It's 5% of the fair market value. So if you had a home that was worth $500,000, the cost of probate would be about 25%. $25,000, not 25%. 5% of 500,000 is $25,000. So there's a huge price tag associated with probate. Many people don't know that, but those are just a couple of things that you should think about. The other thing is, so let's say you don't have assets that are worth more than $166,000. You don't own real estate, you rent. You don't have a bank account with that much money in it, and you have minor beneficiaries, you have young kids, or you have beneficiaries, nieces and nephews if you don't have children that you want to leave your assets to. And let's say instead of having real estate, you have $500,000 in life insurance or $250,000 in life insurance, and you have a 5-year-old child. So and many people I know have left their children as beneficiaries, their minor children. So something to be aware of, your minor children cannot receive assets. They have to be 18. So if you passed away and you had named your minor child or minor children as your beneficiaries, that account would be pulled into probate. So you can figure out what that cost would look like based on the value of the account. What would happen is that a judge would be deciding, who would be the guardian of this money for your child? And it might not be the people that you would want. So that's number one. You might want to think about instead, if it's important to you, well, here's the other thing as well. Of course, if they have a $500,000 life insurance policy that is payable to your child, that money will be managed by their financial guardian, and then they will get whatever is left when they turn 18. So if there's still a couple $100,000, your children or your beneficiaries, when they turn 18, are going to get that money in hand. Need to really think about whether that's what you want. Whether you want your young kids to be coming into a couple $100,000 in hand when they graduate from high school. Most parents, most adults don't want their minor beneficiaries coming into a bunch of money. And so that's one of the downsides of having an account and young beneficiaries without having a mechanism to basically protect them from themselves. So even if you don't have the kind of titled assets like bank account or real estate that exceeds the $166,000 mark, if you have retirement accounts or life insurance accounts that are beneficiary designated and you've left minor beneficiaries as the beneficiaries, you might want to think about putting in place a trust. So, of course, the way the trust helps you there is, number one, it avoids being probated. It avoids those accounts going into probate because you have a minor beneficiary. And the other really important thing is it gives you the ability to make sure that your young child or your young beneficiary would not come into that money too soon. My kids are 23 and 21, and we still don't feel like they're quite old enough yet to manage the assets that they would receive if something happened to my husband and I. So really important to think about, what does that do to a young person to come into money so young? Especially when they've just finished high school, they don't have a lot of life experience, and they definitely don't have experience investing or managing money of their own, money that they've worked for. It can be pretty disastrous. So think about what that feels like to you in your gut, to think that the money that you've worked really hard for, the life insurance that you've paid that premium on, could be gone within a year or two, frittered away on something that's not terribly meaningful. The other thing about the money being gone quickly is that it can really delay the maturation process for your young beneficiaries. Sometimes people come into money and they put off going to college. They put off really kind of stepping into their own responsibility because they've got this windfall that they receive through an inheritance. So something to think about, even if you don't have those titled assets, but you've got minor beneficiaries, you might want to consider putting a trust in place to make sure that you have a way to, of course, avoid probate if your children were to inherit that money. Avoid having a guardian named over that cash that you don't even know or would not approve of. But also, and most importantly, to set up a plan that ensures your children or your beneficiaries would receive the money in a way and at a time that you felt it was most beneficial for their development and their happiness. I mean, after all, that is what a legacy is about, right? It is about being thoughtful in creating a plan that is going to best benefit the people that we love most in our lives. So thank you so much for tuning in to another edition of Catching Up with Christine. If you like our content, please subscribe to our YouTube channel. You'll get notifications when we upload new content, which we're doing on a regular basis. If you have thoughts about this, put them in the comments, and I'd love to see your comments on this, and I'll be happy to respond. If you want to know more about this, give us a call. Go check out our website, kavafaulkner.com. It's a great resource. We have lots of blog posts as well, and we look forward to interacting with you again. Take care.